International Criminal Tribunal for the former Yugoslavia is now in session. L'audience Tribunal Penal International pour l'ex-Yougoslavie est ouverte. Please be seated.
Yes, Mr. Nice.
Just to pick up where we left off yesterday, there are available for the chamber a copy or copies of binders of the type we discussed yesterday. Because the binders were prepared to reflect the indictments, either a binder dealing with deportations or binders dealing with what are described as killing sites individually. And the sample I have before me, and which is available to the chamber, relates to the killing site of Milosevic.
We haven't got it.
It's down there, coming up.
Are they all Milosevic? They're all Milosevic, and that's actually one of their copies. There's
Right.
two of them.
There are two copies coming up, Milosevic.
Mr. Nice, you can introduce this document now, but we don't want to waste too much time
No,
on it. We'll need to read it.
But if I can just, I think it's pretty nearly self-explanatory. Comes in this particular site in 2 volumes. There's an index at the beginning of the first volume. And the only way in which this differs from the binders served on the accused and the amici is that this does not contain the statements it was proposed to tender under 92 bis, whereas their binders did. You'll find within it, as I explained yesterday, a passage from the indictment, an investigator's summary statement, various photographs, maps, and so on, the report of the forensic exhumation team, and associated photographs that connect to that. So probably that's as much as I need say by way of introduction, and if I can invite the chamber to look at them in due course and return to them when it's convenient. And here's a third copy, so that the chamber can have one each. He's already had them. The second thing, if that's convenient to move on, the second issue that I touched on yesterday and said I'd like leave to return to today relates to the possible amendment of the order in relation to service of lists of exhibits and witnesses and a pre-trial brief in the Croatia-Bosnia part of the indictment or the trial.
Just one moment. It may save some time if we confer. You can have until the 31st, or rather the 30th of April it will be, but no further extensions after that. The rule will be applied in the usual way, which is that all the material which the rule requires will have to be provided in. If there are applications to provide further material, of course, we would consider them.
I'm grateful to the chamber for that, and of course this is one of those cases where a little more time will enable us to reduce lists, we hope, substantially by then.
Very well.
Third point that's outstanding, and I'll just, if I may, because I think it will ultimately, or may ultimately save time and be useful, just take a moment or so with it, is the documents that I am proposing to prepare in any event, but that I think may be susceptible to a measure of joint preparation or cooperation. There's already before you, it can be called various things. It can be called a tracking document or a fill box document, but nevertheless its composition is pretty obvious. This is the fatter document, and it's entirely empty at the moment, but you'll see what it is. It simply takes the indictment and breaks it down. At the moment, literally word for word. It's in the vernacular of computer workings, cut and paste, so that the left-hand column simply takes a part of the indictment, breaks it down, puts it in a box, and then the remaining columns to the right of that allow for the possibility of witness testimony in summary form with transcript page references to fill those boxes. And it becomes particularly important once we move beyond the introductory paragraphs to the particular counts. I'm afraid the pages haven't been page numbered, but because the document is at the moment too large to be a single document. But if you go to the third section of the stapled sections, you'll find something that's headed forcible transfer. And so here's the allegations under count 2, that forces of the Fry in Serbia in a deliberate and systematic way did this and that. Witnesses can then be identified in summary form along with exhibits, and slowly the document will fill up. Now, can I then take you, please, to the sample document that's been very helpfully provided by Mr. Higgins for me. A sample document said to be for display only, which gives an example of how this document may ultimately be valuable to the trial chamber. This picks up from paragraph 63A of the indictment. Rahovac sets out on the left-hand side the allegation, and the document assumes that 2 witnesses, John and Jane Doe, have given evidence. The summary of their evidence is set out there, the exhibit that they will have produced, and then at the moment in the comments column it says simply no comment. Now, this document, if we prepare it, and if it's, for example, subject to corrections by the Amici, and were the chamber in a position through its officers to suggest any other corrections, could become a document that could be common to all parties as the trial develops. And at the end, that column on the right-hand side, comments, could of course become 2 or 3 columns, and at the closing brief stage, all parties could make their comments, and so that the chamber could see in a snapshot what each party was saying about any particular allegation. This document is, of course, particularly valuable at the end of the prosecution's case, because at that stage, any box that has no entry in it is a box for which there is no evidence, and one can then simply immediately concede that that count has not been established. The same material that can be contained on this sort of tracking document, if we look at, say, the witness John Doe, and if you now turn to the single sheet, can be set out on another document which simply deals with the same material, that is a summary of the witness's evidence, but this time witness by witness rather than allegation by allegation. And so on the sample page you now have, you see the date is set out, that is the date when the witness gave evidence. The witness's name is set out, and the importance of having it in that format is that computer technology would always enable these documents to be resorted so that the witnesses are either dealt with alphabetically or chronologically according to when they were called. There's then the summary of the witness's evidence, matching, of course, what would appear on the other document. And then there are various boxes for comments. it's not suggested that these comments should be filled in as the trial is going on. They could, of course, be kept blank until the end of the case, but in the same way as the first document will be susceptible to comments from all relevant parties, providing the Chamber with a snapshot view of the competing arguments about events, you could be provided by this document with a snapshot view of arguments about particular witnesses.
Mr. Nice, what exactly is the purpose of this document? Is it to assist the parties, or is it ultimately to be of assistance to the Chamber in its work?
It's both. Its principal focus is to assist the Chamber in its work, because my experience is that these documents are, or something similar, are necessary for the parties to prepare in order to make their arguments and likely to be helpful to the Chamber.
So the prosecution comments would be prepared by the prosecution, no doubt, and the defense comments by the defense, and the comments by the amici, and this would reflect their assessment of the evidence.
Yes.
But quite frankly, I would not find it appropriate, speaking for myself, because I believe that ultimately it is for the Chamber to assess the evidence. And the Chamber should not be assisted in this way, in my view, by counsel. We will have, at the end of the case, addresses by counsel, and in those addresses we will have their assessment of the evidence. But I personally would find this a little intrusive on my work as a judge in the Chamber. I'd prefer to have my own assessment of the evidence. For example, even the summary. Who would prepare the summary of the evidence?
Well, can I deal with those comments in reverse order? I'm surprised that Your Honour would find it unhelpful to have comments by the parties on the witnesses, because, of course, typically at the end of any trial, the parties do provide those comments. One of the problems with cases of this scale is that closing arguments simply cannot deal with every witness, and it's never been the case that counsel have been in a position to attempt to do so. Indeed, in the last case that I appeared in before Your Honour, in a 3-hour closing, which was a 4-hour closing, which was permitted to the prosecution, it was obviously not going to be possible to provide comments on witnesses one by one. That would have been wholly unrealistic. And indeed, in a 100-page closing brief, it would be a waste of resources, a waste of available pages to attempt to deal with witnesses individually. And indeed, in that case, as the Chamber will, I think, recall, one of the documents we did provide was a document that provided the sort of comments on witnesses that we hoped would be valuable if the Chamber decided it needed to consider the credibility or so on of any particular witness, typically defence witnesses in that case. So that I'm afraid I stand entirely by the potential utility of this document. It is essential that parties to a criminal trial are in a position to make their submissions about witnesses or about evidence available to the Chamber. But in trials of this scale, it is necessary to take imaginative steps to enable that to happen without seeking wholly excessive periods of time in oral argument to present material. Further, there can be no unfairness because, and Your Honour asked me, was this to help the Chamber or to help the parties? There can be no unfairness because one of the particular purposes of this document is to enable the accused, who is unrepresented, to have a way of marshalling his comments, if he wishes so to do, and to present them to a Chamber in a way that will be readily accessible.
Let me give you an example of what I mean. John Doe, 2nd May. There's a summary. The summary is presumably prepared by whom?
That's coming to that. That would be prepared by us, but as I've already said, it could be the subject of discussion with the amici. It could be the subject, if the Chamber so decided, with those who prepare such documents for the Chamber.
I really believe that would be highly questionable.
Well, then
I mean, as a document for the parties themselves, yes. Yeah. But, for example, prosecution comments on John Doe. Doe was a credible witness. I mean, that's what I would expect the prosecution to say. It is still a matter for the Chamber ultimately to decide on the credibility of the witness. So that wouldn't take us very far the chamber would still have to read that witness's evidence and assess the credibility of the witness. So I don't see how a statement from the prosecution that Doe was a credible witness who could provide first-hand testimony would be very helpful, because that is a matter which the chamber would itself have to determine after reading the evidence in its entirety.
Well, Your Honour, of course, and the particular comments here may not be typical of the comments that you would receive. Comments you might receive, for example, following Mr. Reinveld's careful examination of the witness yesterday, might include such things as witness omitted passages X, Y, and Z, drawn to the chamber's attention. Notwithstanding that, chamber invited to approach witness on this basis. Precisely the comments that in this type of trial are made by counsel to the judge or to a jury, to the judge at the end of the process. This is designed to be helpful. It's designed to enable in a manageable way the duties of counsel prosecuting and appearing for the amici to be performed in a setting where the accused will not be disadvantaged by his being unrepresented. Now, as to the summary, of course, the summary, which will attempt to be neutral and fair, will come from one of the parties. Somebody's got to take the initiative. And I'm quite content to stop at any negotiations, as it were, with the amici themselves and to present the document in that form. What I am concerned about, and let me be quite blunt about this, what I am concerned about is that in cases of this sort, it may inevitably be that a chamber will proceed in due course in part on summaries. It is infinitely preferable in our respectful submission that wherever possible, the summary or a summary upon which the chamber may proceed can be a transparent document looked at and considered by all parties and in particular by the defence. So that our proposal remains, if I may say so, one that we invite you to consider helpful, constructive and positive, a proposal that we should prepare a document in broadly these forms or this form.
Mr. Nice, the comment you just made goes to the very heart of the matter, which is that in your view, in your respectful submission, the chamber should, wherever possible, proceed on a summary, which is a transparent document. The chamber proceeds on the basis of the evidence given in court. That is what the chamber proceeds on, not on the basis of any summary. And if the chamber has a summary, it must be the chamber's own summary. It can't be a summary in which the parties have participated in the preparation of, in my view. And we'll hear your submissions, but ultimately it is for the chamber, on an assessment of the evidence, to determine the credibility of the witness, the trustworthiness of each witness. And I'm not inflexible on this, and we'll take the document and we'll consider it. But those are the views I have at this moment on it. Yes.
Well, Mr. Nice, I think we have your points. This is essentially a closing brief for the prosecution. Now, it may well be extremely useful as a document to put before us if there's a submission at half-time. It may be extremely useful as a document instead of a closing brief or attached to a closing brief, in which you set out your summary, your list of evidence on a particular point, your comments about the witnesses. All that we accept. But I think we are agreed that as a working document, it is not going to be of assistance to us. Frankly, the Chamber must do its own work and its own assessment, as it will. It will be assisted by the Chamber, by the parties where necessary. In particular, it's not an appropriate course, it seems to me, in a case in which the accused is in person. be different perhaps if he was represented, but there again, that's open to argument. But since he's in person, it isn't. If the amicus, on reflection, wished to add something to the schedule and prepared to do that, then of course that might be helpful, but it would be a matter for them.
Well, Honour, I'm grateful for the expression of views, and I take no more time than, if I may, just 2 points. One, of course, in answer to His Honour Judge Robinson's point, I wasn't saying that it was inevitable that and desirable that you would proceed on a summary. Obviously, and we know this from the judgments that we receive, the Chamber must go back to the transcript, but it gets to the transcript via a document, and this may be a document that would be helpful. So that's the first point. And the second point is that this is not, in answer to Your Honour, His Honour Judge May's characterization. Although this would become part of the prosecution brief, as it has done in other cases, its purpose, and the reason I raise it now, includes that it can help the accused, who has chosen to be unrepresented, to present his comments in an orderly way that might assist you, because otherwise you may not have his comments available in that form. What I will do is I will carry on preparing this document, and I'll negotiate with the amici and see if they wish to receive it from time to time. If they do, then the document will have that perhaps additional value at the time we come to present it, as we will, as part of our closing. Thank you for the time in relation to that.
We will return the documents, if we may.
Thank you very much. And that leaves 92 bis and the scope of cross-examination, I think, now for next week. Ms. Romano will call the next witness.
There may be some matters the amicus wants to raise, and also the accused, who was told he would have that opportunity.
Your Honours, very briefly, I must admit that I did not quite understand the idea that was presented by Mr. Jeffrey Nice, because I think that evidence has to be produced here before you. It has to be fully presented here, and then while it is presented, objections may be raised. And I certainly cannot understand that Mr. Nice speaks of imagination when evidence is concerned. That is my main objection. And I think that when evidence is produced, we are going to react to evidence that is on the table right then. And that is the only way I think we can proceed.
Obzirom na vašu naredbu, odnosno na vaš nalog,
in view of your ruling,
tiče nas,
that has to do with us, the Amici Curiae, that you addressed to us on the 11th of January 2002, where you said quite clearly that we should assist the trial chamber in every possible way that we deem appropriate at that moment. Yesterday, I discussed this only very briefly with Mr. Kay. During the proceedings, you have heard Slobodan Milošević already twice here before you, and once on that day when the hearing was held before the appeals chamber. He asked for his own release, but not release for the sake of freedom as such, but primarily freedom that would make it possible for him to be on a footing of equality with the opposing party. You are fully aware of the fact that this is the first case in which a person is defending himself on his own completely.
vrlo
The court is
delikatna.
indeed in a
Vi
delicate
znate da
situation.
pravilo 45
You know that
predviđa
Rule
ono
45
zašto se odlučio
envisages
Slobodan
the
Milošević,
possibility
ali
that
bih ja
Milosevic opted
pažnju
for.
veću u ovom momentu
But at this
skoncentrisao
moment, I would
na
like
statut
to focus the attention
statut,
of the trial chamber on the
tribunala,
statute. The statute
govori o
of the
tome
tribunal
da se
that says
svakom optuženom
that every
mora
accused
obezbediti minimum jemstva
must be
da ima
provided a
odgovarajuće
minimum
vreme i
guarantee of
sredstva za
having
pripremu odbrane.
adequate
U ovoj
time and
verziji koja je na srpskom jeziku
resources
mislim
to
da
prepare
je
his defense.
loše
This
to
is the
prevedeno.
Serbian version, and
Ja ću
I don't
pročitati
think
jedan
the
deo samo iz
translation is
francuskog,
proper. I'm
iz
going
francuske
to
verzije,
read
da se
from
kaže
the
a
French version
disposer
now.
du temps et des facilités nécessaires à la préparation.
Mr. Tapuskovich, would you just pause a minute? If you're going to make an application for provisional release, and you seem to be, I'm not sure that this is the right time to be doing it. It may be appropriate when we've got witnesses waiting. It may be appropriate later. But let me consult.
Biću kratak, sudija.
To be very brief, Judge May, very
Nije ni u
brief.
ovom momentu smisao to.
That is not my point right now, although we have to think about that as well, and perhaps the trial chamber should give due consideration to this as well at some point. What I wish to say now is that we have to find the ways and means of enabling Slobodan Milošević to be prepared for every day in court when evidence is being produced. I don't know what kind of proposal I should submit to you at this point in time. I don't know whether these should be counselors that he would select, that he would be in a position to contact every day, and whether these consultations can take place at the detention unit. However, the point of this is that what Slobodan Milošević said yesterday, that he does not even have access to the telephone and that he needs to deal with what has been dealt with in court. So I'm not insisting on provisional release right now and the equality of arms, so to speak. But the trial chamber should simply find ways and means of enabling Slobodan Milošević, since he is unrepresented anyway, to prepare properly for every day in court. That is the point I wish to make now.
If you have a concrete proposal, we'll hear it in due course.
Ja mogu, evo samo mogu da vam kažem odmah.
May I say something straight away? In January,
slobodne razgovore Slobodana
you
Miloševića
allowed free discussions between Slobodan
koje on
Milošević
nije
and
prihvatao.
counselors that he
Ali
did
ako on
not
ima savjetnike
accept.
koje prihvata,
However, if he
onda
has
bi
advisors
prosto
that
trebalo
he
da mu se
does
omogući
accept,
da se
then he
njima
should simply
razgovara,
be
dogovara se i da vidi
in a
kako će u
position to
konkretnoj
talk to
situaciji da
them, to
postupa
discuss
ako
things with
se
them,
već
and to
sam brani.
see
Mi sa
how
Slobodanom
he is
Miloševićem
going to act in
nemamo
certain
kontakt. Vi
situations,
znate da taj
since he
kontakt
is
mi
defending
ne
himself
izbegavamo.
anyway.
Mi
We
taj
do not
kontakt
have any
možemo
contact
da
with
ostvarimo
Slobodan
samo uz
Milošević.
vašu
You
saglasnost
know
ako on
that
to
we are
traži.
not avoiding
Ali u
this
ovoj situaciji
contact,
smatram za
and we
potrebno
can have
da vam
this
samo toliko
contact on
kažem.
the basis of your ruling, but we deem that this would be necessary one way or the other, and that is the point I wish to make to you right now.
Mr. Tapuskovich, in the light of what you just said, are you saying that there is anything now that stands in the way of Mr. Milosevic having contact with his associates and other people to provide him assistance? If that is so, I would consider that a very serious matter, which would require very urgent attention by the chamber.
Yes. Najpre, uvaženi sudija,
Your Honor, Judge Robinson, first and foremost, that is a problem that he indicated to you yesterday, that he does not even have telephone links to anyone any longer. But I think that
That is not so. He does have telephone links.
No, u redu, telefon nije dovoljan za tako nešto.
However,
Ja mislim da može da se pronađe rješenje i da sud sigurno može da pronađe rješenje da omogući ukoliko Slobodan Milošević želi stalni kontakt, slobodan kontakt sa savjetnicima, ja mislim da tu ne bi trebalo da bude problema da mu se to omogući ako hoćemo da ga stavimo u poziciju da može da mu se garantuje minimum mjesta da se valjano pripremi za suđenje. Ja mislim da tu ne bi trebalo da bude teškoća u granicama mogućnosti koje postoje u zatvoru.
Within the boundaries and the limits in the prison, of course.
It will certainly have my full support, because as you say, that's a right which he has not only under the statute, but under customary international law, to have adequate facilities for the preparation of his defense. But let us know concretely what it is that you have in mind. The telephone matter, as far as I'm aware, as far as the chamber is aware, has been addressed. You know? If there is still a problem with the telephone, then let us know. You know?
No, da vas ne bih dalje zamarao,
I don't want to keep you any longer. I shall try, together with my colleagues, to perhaps write some submissions to this effect. But this seems to be a problem to me, a problem that, to my mind, requires a solution.
Very well. Thank you. Yes, Mr. Milosevic, you were told you would have an opportunity to raise any matters. You can do so now.
Microphone, please. I would like to continue along identical lines, perhaps not altogether identical, regarding this subject that has been raised by one of the ICTY. You know full well that the fundamental right that is guaranteed by the International Covenant on International Political and Civil Rights, and there is a European, an African, and American declaration to this effect. A basic right is the right to defense. I have fully been denied this right through this isolation, and it is quite clear that no mention can be made of a fair trial here or equality of arms. I have no conditions whatsoever for defending myself here. On the other hand, all of you know full well that I am not going to run away from this place of force and injustice where my people and where my country are being defended, because these are the gravest possible accusations.
We are not impressed by your political points. You have made them a great many times. They do not improve with repetition. Now, if you have a serious application to make to this trial chamber, will you make it? Tell us what it is you're asking for, and we will consider it.
Very seriously, there is not a more serious question that I'm raising, more serious than that one, and that is for you to release me. And you know full well